Okay, well, good morning, everybody in the UK. Good afternoon, everybody in China, and hello, everyone in between. And welcome to our session today on IP protection for British design in China. This is one of a number of webinars that we do on this topic. We've done quite a few in recent times, and we will do plenty more, and I will share some more information about previous ones and upcoming ones in due course. This is, of course, a really important consideration for companies of all industries at any stage of their market entry in China to be well aware of their IP issues and to make sure that they're properly protected and properly covered. We're delighted to do this in partnership with the IPO and Tom Duke and his team, as we pretty much always do on this topic. Our expert today is Christine Yu, a partner from Bird & Bird, and I said as our topic is a little more specific on British design in China. So I'll introduce Christine a little bit later on and introduce a little bit of the context of what we're going to talk about. So before we begin, just for those of you who don't know who we are, the China-Britain Business Council is the leading organisation helping UK companies grow and develop their business with China. CBBC supports companies of all stages and at every stage of market entry with practical in-market assistance, services, industry initiatives, as well as a membership programme offering access, seminars, and significant networking. CBBC works closely with UKTI and the FCO and has a strategic partnership with the British Chamber of Commerce in Beijing, in Guangzhou and Chengdu, Chongqing, providing corporate members with reciprocal membership. Our business-led board and professional team have extensive first-hand experience of doing business in China, and through over 60 years of engagement, CBBC has built up exceptional connections with government and business across China. CBBC services are delivered across a network of 10 offices in the UK and 13 strategic locations across China. CBBC helps companies to network and learn from China-savvy multinationals and SMEs to understand the intricacies of doing business in China and to develop sound strategies for expanding in the fast-changing and dynamic marketplace that is modern China. So that's just a little bit of background of who we are as an organization. Now, for today's session, we like this to be an interactive session. So if you have any questions at any time, please feel free to type them into the area that I am highlighting here. They'll then pop up on my screen, and if they're relevant to what the presenter is talking about at that time, I might just interrupt them and ask them to do with your question directly, or I'll hold it to the end for a Q&A session. And if we don't get to it on the day, I'll be happy to pass it on to the speakers who can follow up afterwards. Just before we begin, if I could ask everybody, please, to click on the Raise Your Hand button that I'm highlighting there, the Raise Your Hand button, and that will just enable me to know that you can all hear me. I always feel a little bit lonely here sitting on my own. I never wonder if anyone can hear me. No one ever listens to me anyway, but if it's literally the case, then it's a bad thing for this morning. Yeah, I can see lots of hands going up. Great. If you have any issue throughout, as I say, be it IT related or indeed on the content, just drop the question into the area that I'm highlighting there. All right, before we begin, I'd like to just drop in a poll if I could. And this just helps us to understand a little bit more about who you are. So I'm just going to launch this poll now, and it's a simple poll. Where are you? Are you China, UK outside London, UK London, or other? And we'll drop in another few polls as we go along. This helps our speakers understand who's listening, and they can then tailor a little bit of what they say to be more specific and relevant to our listeners today. So nearly everybody. We've got most people voting. Very good. And I can quickly share those results with you. And we can see that 27% of people are in China, 55% of people are UK outside London, 9% London, and 9% in the magical, wonderful, mysterious other. I always say this, but it's great to have UK outside of London as the majority, as it always is on this platform. This webinar platform allows us to get information to people who mightn't be able to travel to an event in London where we hold one, or we mightn't be able to hold an event in their specific region if there isn't maybe a critical mass of attendees to warrant the infrastructure and the time and all of that kind of stuff. So this platform is really valuable for us. We've done about 50 webinars on all sorts of different topics. So I advise you to go to our website, look for webinars, or go to our YouTube page where we also host them, and you'll find all sorts of background and all sorts of useful information, not just on IP, but on other aspects of doing business in China. So just to introduce our speaker today, our speaker is Christine Yu. She is a partner in the intellectual property group at Bird & Bird based in Shanghai, and she specializes in all areas of IP with a focus on litigation in mainland China and Hong Kong. Christine has a broad range of expertise in handling patent, utility model, trade secret, trademark, unfair competition, copyright and design infringement, and invalidation disputes. So there are a few people better placed to lead us on to today's discussion. Before we begin, I'd like to just invite Tom Duke. I don't have a bio for him today, but most of you hopefully will know who he is. If you don't, you should. Tom, please introduce yourself quickly when we get there. But Tom will just give a little bit of a background on the work that the IPO does on behalf of the British government for UK companies in China. Tom, over to you.
Thank you very much, David. Hello, everybody. My name is Tom Duke. I'm the UK's intellectual property attaché to China. I'm based here in the British Embassy in Beijing, where I'm speaking to you from today. I am also the UK Intellectual Property Office's representative here, covering mainland China and Hong Kong. My role is today is to give you a quick introduction and to set up the talk that Christine and her colleague Yijing Ge will give us in a short moment. I'll give a little bit of background as to why designs in China are important for UK business based on the experience that I have supporting British businesses here in China, and also a little bit of context about the design system in China, the IP system in China, and some of the work that we have been doing to help companies in the UK protect their rights and do business here. I'll only speak for a few minutes, and we'll leave the bulk of the time today for our expert speakers. So let me kick off. The designs in China are increasingly important for British businesses. There are a number of different business models that are used by British companies to enter the Chinese market or to do business alongside entities in China. So in the design sector, or the design-intensive industry sector, this may be, for example, engaging in contract manufacturing or original equipment manufacturing or OEM arrangements with Chinese partners. So effectively outsourcing manufacturing to entities within China, which as part of that contract and that business relationship will often involve licensing of intellectual property and product design as part of that process. Other companies may be selling products into China, so they may have products which feature design elements and are design intensive being sold into the fast-growing Chinese consumer market or indeed into industrial applications within China. Or British companies may be providing design services to Chinese manufacturers or other Chinese businesses. The UK, in addition to being a very strong and high-end manufacturing country, also has a large number of world-leading design services companies. There may be other companies that don't have a business footprint directly in China, so are not manufacturing here and are not selling here, but that nevertheless are impacted by companies that are doing business based in China. Typically, this may result in concerns over IP infringements. So there might be Chinese companies that are manufacturing products, shipping them both within China and around the world, which infringe upon design rights and other intellectual property rights owned by companies based in the UK. These may come to your attention by trade fairs, participating in trade fairs, and noticing that people are selling infringing products, or by looking online. So, for example, on an Alibaba platform or other e-commerce site, and noticing that people are selling products which potentially infringe your designs. And again, this means that some sort of action needs to be taken in China in order to protect your competitive advantage around the world. So that's not only restricted to the Chinese market. So these are all types of business operation or elements of business in the business environment which may result in people needing to think about design protection within China and the enforcement of registered and protected designs using the Chinese administrative and IP legal systems. Our expert speakers in a moment will speak in more detail about how you can engage with that system, both how you can protect your designs and how you can enforce against infringements of them. But by way of context, the Chinese IP system is now operating on a huge volume and is developing incredibly quickly from a very low base. 30 years ago, there was really no IP system in China, and there was no enforcement system or court system to support IP protection within the Chinese mainland. Over the past 30 years, this has developed very, very quickly, and now we have a huge number of applications for design rights in China at the State Intellectual Property Office. There were 592,000 applications for designs in China last year, the vast majority of those coming from domestic Chinese companies, which signals that Chinese companies and the Chinese government is increasingly taking the IP system very, very seriously. At the same time, Chinese companies are also enforcing their IP rights in large numbers. There are over 95,000 first instance civil IP cases that went through the Chinese courts last year. And again, the vast majority of these were Chinese companies in disputes with other Chinese companies. Less than 2% of those cases involved a foreign party, which is a statistic that sometimes surprises people. So IP in China is no longer a foreign policy issue. It's very much a domestic policy. The Chinese companies and the Chinese government take this very seriously and are continuing to evolve and improve the Chinese IP system to suit the needs of these companies, which are now creating and developing their own innovative and creative products. This does bring the interest of a large number of Chinese companies into line with the interest of design-intensive UK companies. And some of the problems that we hear from British companies as they navigate the Chinese system are shared by domestic Chinese companies as they become more innovative and create their own IP. So that's a little bit about the context to which you will be entering as you look to protect and enforce design rights in China. On the enforcement front, there are a number of options, and Christine and Yi-Jun will go into more detail on this in a moment. But looking at it from a broad, high level, there are a number of different channels through which you can enforce IP rights in China. This includes administrative enforcement or enforcement by a local government team, perhaps roughly analogous to a trading standards enforcement unit that we know in the UK. To enforce a design right, you can file a case with the local intellectual property office, which is a branch office of the IPO at national level, based within the local government in cities or districts across the country. This will generally result in a small fine and an administrative order from the local government to stop infringing activity. For more serious cases, you may choose to go through the civil courts and bring a court case and have a specialist judge evaluate the claims and potentially issue an injunction or a court order for the infringing party to stop the infringing behavior and to pay damages awards. And there are other enforcement channels which are perhaps used slightly less for design right infringement, but nevertheless in certain cases can be accessed. So border enforcement is one particularly worth mentioning there, customs enforcement. So Chinese customs can in some cases make seizures against infringing products being exported from China to other countries if the rights owners work closely with the customs agency to enable the seizure and then subsequently bring a case through the courts to determine that infringement has indeed taken place. Customs agencies in China are indeed prepared to do that. There are also, very, very rarely, but potentially there can be criminal sanctions brought against what they call counterfeiting of designs or design patents in China. I say this is very, very rare, and to my knowledge there have been a very, very small number of cases brought over the past few years. So the main channels are administrative enforcement, civil enforcement, and in certain cases, in cooperation with customs agencies, border enforcement. And in addition to these channels, there are, of course, some non-official channels, so channels not operated by government or court institutions. This can include notice and takedown mechanisms through e-commerce sites, and Christine and Yi-Jun will talk in a little while about enforcing through Alibaba and other e-commerce platforms, and can also include cease and desist letters done in cooperation with your legal counsel, and several other channels such as alternative dispute resolution, mediation or arbitration processes, which happen outside of the formal administrative or legal channels presented and operated by the Chinese government. So the message here to take away is that the IP system in China is large, it is dynamic, it is being used on a huge scale by a vast number of foreign companies, but predominantly now domestic companies. There are a number of enforcement channels that can be used to enforce against infringement of protected IP rights in China. And as you formulate a strategy to suit your particular business model, hopefully this webinar and some of the advice that Christine and Yi-Jun will give you in a moment will inform your strategy setting and your discussions there. Quickly before we hand over to Christine and Yi-Jun, I'd like to mention a couple of initiatives that we are running alongside the China-Britain Business Council and other partners to support UK businesses with protection and enforcement of design rights in China. So David, if you could flick over to the next slide, please. late last year, September last year, we were very happy to support the China-Britain Business Council, CBBC, today's webinar hosts, with the signing of an MOU on intellectual property with the Alibaba Group. The Alibaba Group is China's largest e-commerce platform, accounting for over 80% of the Chinese e-commerce market. It is the largest e-commerce platform in the world. It sells more each year than eBay and Amazon combined. It is an absolutely huge platform, and it is crucial to the e-commerce environment in China. The CBBC signed this MOU with Alibaba last year, with our support, and have held a series of roundtable meetings with the Alibaba Internet Security Division, focusing on a number of different industries and key difficulties that British companies have found enforcing IP rights through the Alibaba platform. I would like to mention quickly here that the next roundtable meeting will be held in Hangzhou in a couple of weeks' time on Monday, August the 10th, and this will particularly focus on patent and design rights protected products, so particularly relevant to today's webinar, looking at, for example, products in the furniture industry, household appliances, and other products. So if you have any thoughts about IP enforcement on Alibaba platforms, if you would like to travel to Hangzhou, about an hour and a half train ride from Shanghai, and participate in that session, you're very, very welcome to. Or if you'd like to feed in information or see a readout of the meeting after it happens, please do get in touch with Mick Ryan at the CBBC office in Shanghai, and his contact details are on the screen there and will be circulated after this webinar when the presentation files are disseminated. And another initiative I'd like to quickly mention is a business fact sheet. So next slide, please, David. This business fact sheet covers many of the topics which will be discussed during today's webinar. It covers IP and 3D product design in China. It was written by Christine and Yijun, and they will pull out some of the main messages from it in their presentation subsequently. But it was also written in collaboration with the Anti-Copying in Design Industry Association and the CBBC. Anti-Copying in Design, or ACID, are a UK-based organization. Many of the people participating in the webinar today may well be members of ACID, who look out for their members' interests in regard to copying and IP infringement of designs, both in the UK but also internationally. And ACID has been a very good partner for ourselves, for the UK IPO and the CBBC, in helping to get information out to companies and helping companies to access the support that me and my team offer here from the embassy in Beijing, and also that the CBBC offers across the country. So take a look at the fact sheet if you haven't done so already after this session, and if you have any further questions on that, please feel free to direct them either to myself or indeed to the two speakers who will follow me, who were the authors of that fact sheet. So thank you very much. I hope this introduction has helped to set up the talk that you will now hear from Christine and Yijun, and I'll be hanging around to participate in the question and answer session towards the end of this webinar if you have any questions that you would like to direct specifically towards me. Thank you, David, and back to you in London.
Thanks very much. Thanks for that, putting a bit of context on everything for us today. For those of you listening in, as I said, if you don't know Tom, find out about Tom, because his organization is pivotal to supporting UK companies and their interests in IP throughout the world, really. There's a number of attaches in different significant developing markets around the world, so I think it's definitely worth getting in touch. All right, so now let me just check in and do one of my little scary moments and just check that our speakers in Shanghai are out there. My colleague Mick is online with Christine. Are you guys there?
Yes, we are. Thank you.
Fantastic. Okay, well, just before we begin, I'm going to do one more quick poll, and this might help you a little bit. So I just want to ask people which of the below best describes your interest in design in China. So I'm just going to launch that now. Contract manufacturing, selling products or design, enforcing against infringements. So let's just give our speaker, Christine, just a little bit of context as to who's listening. You know, who makes up our who makes up our group. So you might be working on legal teams inside companies, or you might be just part of the manufacturing side, or you might be on the professional services side. So if you could just click on that. While we're doing that, I'll ask Christine, how's the weather in Shanghai? Is it a nice day?
Very, very hot. We are into the 40 degrees, but we have blue skies, so always fine.
Blue skies in Shanghai. Wow. Okay, that's fun. All right, we just finished this, so I'm just going to close it, and I'm just going to share the results so everybody knows. So 11% contract manufacturing OEM, 11% selling products, 54% enforcing against infringements, and once again 25% magical others. So that just gives a bit of a context of the makeup of our listenership today. Okay, Christine, absolutely over to you now.
Thank you. Can I have my slides back on the screen?
Yes, you can. Let me just do that now. I thought I had.
The result is very, very interesting because we can see that people are interested about the enforcing their rights, even when they're not selling in China. I think that's a very correct concept. Can I begin with the next slide?
Absolutely.
Thank you. So I think we can start the presentation by just have a quick glance at what's happening, what kind of infringement are we seeing. As people expect, there's still a lot of copying happening in China. It's hardly surprising because China is still a manufacturing country. And there's a lot of factories in different parts, in the southern parts and in Guangdong, where we see most of the cases. So infringement can happen in different shapes and sizes. You can see that as soon as the Apple Watch was launched, there will be there are already products offered on the Alibaba site that Tom mentioned at a fraction of the price, only 250 renminbi, and that's like 20 quid. With a smartwatch, identical user interface, and it's even the Android version that can communicate with your Samsung phone. So it's on the face of it, it's a very short, very small company that does it. So annoyingly, for these companies, they are like pop-up stores. You close one down, another pop-up. You close one down, another pop-up. On the other hand, you can also see that there are competitors that deliberately copy so as to profits from the amount of values that go into innovative design. Dyson, who aggressively protect their rights in China and in elsewhere, for example, faces infringement issue from a company called Vex, and it's owned by a Chinese company, Tektronix, as the major shareholders. So again, the design war is launched not in China, but everywhere else in the world, in UK as well as in France. And then copying can take place in very big scale, like in this, we have a fake Disney park, or even a fake Eiffel Tower, or a town that's modeled after a British Georgian townhouse or Thames River townhouses, etc. So infringement can take place on very, very large scale as well. And what's the relevance? I mean, maybe there are companies who are smaller than Apple and Dyson, and what's the implication for them? So looking at how many infringements are there, I think a very common misconception is that, well, there's no protection. Clearly, there's no protection anyway. Otherwise, if the system is working, there won't be that much infringement. And I think the purpose of this presentation is to tell people what can be done, because if you deliberately choose to let go of registering your rights in the Chinese market, or even rely on your OEM, the trust of your OEM to do that, then the effect is not just contained in China, but you see that products that are being made in China are then sold on the internet or via the export channel to other places. And because those goods are being put legitimately on the market in the first place, there's very little that people can do. And the second misconception is to rely on the general concept of fairness. And the concepts like, okay, this design first came up by our company, we put a lot of innovation into it, so there must be some fairness in the law that can protect us. Again, the law contains lots of small prints, and so the purpose of the presentation is to tell you how to navigate and make use of the law to protect your rights. So with this, I can go to the next slide. So the agenda for today, firstly, I want to talk about what's the regime for protecting 3D designs. And then we will offer some practical perspective looking at cases that happens and design that's registered by other people, including what works and what does not work. And lastly, I want to open the floor to questions from you. We can share what kind of frustration people have experienced from using the administrative or civil channel in China, and then we can have a discussion on is there anything we can do to improve that. So next slide. Right, so let's start with IP protection for 3D design. How can it be protected? So when we talk about design and the possible IP right that can be contained in it, it can be a number of different laws offer protection. The most important one will be design patents. The other type is copyright, and 3D design can also be protected in the form of a 3D trademarks or as trade dress. And there's nothing that prevents a right owners to make use of one or more of these rights. For example, I think there's a case where the owner of a Parker pen, they first have a design patent over the shape of the pen. And then the patent expires because design patent is only valid for 10 years in China. And then they are able to rely on trade dress because the clip of the pen is very distinctive in indicating the source of the product coming from a particular company. So copying of that shape of the clip would again constitute an infringement as long as the side shape of the clip is very distinctive. So I think the encouragement is for people to really think outside the box and observe the change in law and think about, okay, even if I forget to register my design patent, is there any other rights that can protect me? So next slide. So the most important way to protect a design in China would be via design patents. In Europe and in UK, design is not categorized as a type of patent, but is categorized as a standalone system. We call it a Cinderella system of IP. But in China, it belongs to the bigger family of patents. The substantive law, however, is quite similar to that of the UK. So the subject matter that can be protected would be the appearances, shape, pattern of a product, or a combination of color and shape or color and pattern. There can be a number of different types of design, and we can go to the next slide, please, for some examples. So the type of design that can be registered ranges from buses, vehicles, automobile design, obviously very important in view of the huge market here, how many people are there, and growing middle class. I think Neoplant obtained a very significant judgment with a large amount of damages in China, relying on their design patent. It's the first case after a series of failure by car manufacturers, including like Honda and a number of others, who failed to register their design patent rights and have to rely on other regime of unfair competition. So I think this case really highlights how effective it can be if you remember to register your rights. Another types of more artistic type of design can be jewelry bracelets. And can I go to the next slide? As well as in the fashion industry, like the Hermes handbag. note that design pattern can be 2D as well as 3D. So your Marks and Spencer type of specific fabric can be subject matter for design pattern, as well as the 3D design of a handbag or a specific cup for a dress. Products in the industry, even though they look very technical and functional, does not necessarily people think of them as design. There's way to protect them as well. For example, the tie. In China, purely functional design, technical part cannot be protected, but that doesn't prevent features that achieve a technical function as well, but not necessarily have the design is solely to achieve a technical purpose. So what this means is, for example, if you look at the example of the tie, the round shape is not protectable, so you can't prevent other people from coming up with a round tie. Never mind with the question of whether that's new or not, because the round shape is to solely dictated by the function that it needs to roll. However, the thread pattern on the rim of the tie, yes, you can say it has a technical function of increasing the friction, but the pattern of the tie can be a subject matter for protection, because you can have many different types of pattern. And sometimes people do use that to identify who the manufacturer is. So some industrial products like actuators can be subject matter of design as well. And surprisingly, like sometimes these designs are really useful in catching counterfeiting, because sometimes the company thinks that they are the value of the product is not in the design, but rather in the trademark. But as trademark infringement is getting more and more difficult, sometimes you get counterfeiters who are very careful, like in coming up with a product in the factories, but they don't put the label on it until it's reached the downstream, like in the lorry or during the delivery process. But if you have a design pattern, then you can catch them even before they put the infringing trademark on the factories. So it achieves same goal via a different way. And in terms of technical functions, as Tom has said, like there are a huge amount of design application nowadays, and it's sometimes very interesting what people will register, like the shape of a chocolate cookie, and there's argument on whether the chocolate chip has a technical function of being enjoyable, and whether or not and what's the design freedom for the shape of a cookie, etc. So people sometimes can be innovative in what they choose to protect. Next slide. So how do you register a design? The application can be made to the State Intellectual Property Office, who oversee all the registration for other types of patents as well. But the application for a design patent does not need to go through substantive examinations. And what this means is when the patent officer receives the application with a drawing and with a specification on what's the aspect of the design, they wouldn't then look into is this a novel design, or is this something that commonly seen in the market, and they will grant a certificate anyway. The question on validity is generally only put in issue when you try to enforce that patent. So the three requirements for the validity of a design is that it must be new, it must be substantially different from prior design, and also that it must not be in conflict with other people's rights. And again, this is very similar to the requirements in the UK. But in terms of numbers, I just want to put in perspective here. We are seeing a lot of Chinese companies filing aggressively on the number of design patents. I think Dyson would be one company that has adopted this strategy of filing a thicket of designs. For example, on their vacuum cylinder, vacuum cleaner, they have got 9 different registrations covering different aspects of the vacuum cleaner. Rolls-Royce, again, another example of company that files a lot of patents, versus some Chinese company are trying to adopt the same strategy. But what's the balance here? I think, of course, not every company would have the budget to file that many patents. But considering how considering the cost of enforcement versus the cost of registration, which is about 2,000 USD, I think it's still worthwhile to if you have a key design, that you should register it as soon as possible before the product is put on market anywhere.
Christine, sorry, I just have a question. This is probably a dumb question, and maybe the people listening know a lot more, but I'm going to ask it anyway. You know, you're talking about the design must be new, substantially different from prior designs. You know, if you're just doing this in China, you can't just take a photocopy of somebody else's product from another country that may not have any legal entity or any representation in China and put your name at the top of it and go in and say this is ours. Is that correct? I mean, is there any situations where that happen, where people are finding that kind of thing happening?
This type of thing is happening for a number of reasons. Some people just want a paper tiger. So the statistic that Tom has put up, there's how many filings in 1 year? Like something like 500,000.
80,000 or something like that, yeah.
Right, and then if you look at the cases where people have really enforced the registration, I have the figures here. It's 6,000. Right, it's 2,500 administrative action taken last year, half of which is in Guangzhou. Perhaps due to the Canton Fair. So what does that mean? Only 0.5% of the registration is being enforced. And that seems to me that a lot of people are registering for other reasons. It can be help with like marketing promotion, or Chinese company get subsidies. So the filing of it actually put no additional financial burden.
Yeah. Okay. Well, I suppose the reason I'm asking, Christine, is that I don't want to muddle up sort of too many legal fields, but we would always recommend to UK companies, even smaller companies, to register their trademarks and register their name and register all of those sorts of things, even if they're not in China. Would you suggest, say, a company that has an innovative product, they're not even in the China market yet, they might be thinking about it in 5 years, maybe they're not ready. Is it essential that they still look to protect their design patents even though they're not in China yet?
Absolutely, absolutely. Because if you look at requirement 1, the design must be new. So this is what we call in legal jargon absolute novelty. Because the concept of it is similar to that of a patent. If you are not the first person to come up with the design, then you lose the right of monopoly to it. So if your product or a design has been put up anywhere else in the world, then it will destroy the possibility of a valid trademark design registration in China. So you might have missed the boat if you register too late. Having said that, can you still do it if you fail to register in the first place? I think but internal, like in one of the partners meeting, we have a real moral discussion on can you register a right knowing that it's invalid. But on a practical level, there is still some practical benefit that can be achieved, I think, if you can show a design certificate to people.
Okay, I mean, I don't want to labor the point. I know we're early in the presentation, but I have a question here from Susan, and I think it's a very relevant question at this point, which is we have a product which has a European design right granted in February of this year. Product first went on sale in March 2014. Can we still register? We have lots of fakes now appearing from China. We have also started to sell in China. So what would you say to Susan?
No, if you ask me, can you obtain a design certificate? The answer is yes, because going to the first point, to obtain a design certificate, you don't need to go through substantive examination. But if you choose to enforce it, can people invalidate that? The answer is also yes, if they would go through the process to challenge the rights, because the standard is absolute novelty. There's no grace period. And then China is not yet a member of the Hague Convention, which means you can't extend an international registration to China. It has to, the IP right is territorial, which means you have to file with the Chinese Intellectual Property Office in order to obtain this monopoly rights in China.
All right, thanks for that. I'll let you get back to your presentation.
Sure. I think I'm ready to go to the next slide. Right. So this is just to give some, I think we've covered that already. So registration with State Intellectual Property Office is required to confer protection. I think that's very important concept, that you need to register with the Chinese authority in order to get protection in China. The timing is about 6 to 8 months, and cost would be around £1,500 per patent. And the terms of protection is just 10 years. And 10 years is shorter than what's more, I think what the UK and European countries offer. But in the next amendment of the patent law that's upcoming, the terms of protection will be increased to 15 years. And again, China is not yet a Hague member country, but soon to be.
Christine,
okay,
just a quick,
next slide.
As we're moving slide, I've just got another quick question. Sometimes when you're dealing with government agencies like this in China, foreign companies often are advised to use an agent.
Sorry, David, we lost you there. Could you repeat that?
Yeah, sorry. So just as we're changing slide, often when UK or international companies are dealing with government agencies to do registrations and all these sorts of things, people recommend that they use an agent or some sort of intermediary. In this case, for registering, is this something that you would recommend, say, a company with a design patent go directly to SIPO, or do you reckon they should go to an agency in between who helps them and makes sure the documents are right, that kind of thing?
Yeah, I would recommend that that you use an agent, because filing of a design patent, there's still a lot of technicality in it, because, for example, do you register one aspect of the design, or do you do a combination of designs, or is there a certain part that would be common configuration, then you choose to use a dotted line to signify that that's not the part that you're trying to protect. What kind of specification do you want to put on the design? So the consideration here is, if you narrow so on your patent, if you specify that you are just protecting one specific aspect, like the shape of a button, then if people copy other parts of your product, then you're going to face difficulty in infringement, because then they're not copying the part that you consider as important. On the other hand, if you decide that your design certificate should be just generally the shape of the product, then the product can cover a number of aspects. And then if the other party only copied a button, then the dynamic is this considered as a substantial similarity to the overall product? So there is still a number of technicality involved in protection, but I think there are more and more patent agents in China that offers protection and registration services on a very reasonable price.
All right, thank you.
So regarding this slide, I want to address the issues with spare parts. Spare part protection is a very important issue around the world because of the size of the market. And there are lots of issues surrounding if the spare part is used to repair, or is a shape that must fit the bigger part of the product is protectable. And I think in China, the law is much more simpler. So the shape of a design is registrable if the spare part, there's a separate market for it if they can be sold or used separately. But there are also rules like the design must be visible when it's being used. So if the spare part is not visible when used, then it cannot be protected. Okay, I can go to the next slide. So moving on to copyright. Well, if you have not registered a design in China, and what else can you do? Copyright is another possibility. So in under the copyright law, 3D design can be protected if it constitutes a work of fine art. So the requirement that it has to be original doesn't mean that it has to be new, but only that you created it. The hurdle for protecting design as copyright rests with the requirement on artistic quality because it's work of fine art. But then 2D drawings will be copyright protectable. So coming up with the large number and the hot topic of 3D printing, if the 3D printing would require a proprietary design drawings, then you can catch infringement by using copyright in that drawing against the infringer. So next slide. Now, in terms of artistic quality, I just want to illustrate what's considered as art and what's not. Surprisingly, so if you look at the IKEA's chair, it's not considered as art. But if you look at the Lego toy blocks, it is considered as art. So it's a little bit of a hit and miss, and that illustrates sometimes the type of frustration in China of why sometimes it seems to work and sometimes it doesn't. It's because we have a large number of courts. China is very big, so it has a huge number of courts which has jurisdiction over IP cases, and sometimes the criteria for decision can be very subjective and sometimes inconsistent. The Lego case is also interesting in illustrating one very Chinese aspect of a case. I think here the right owner alleged infringement of 53 Lego blocks, and then but then the infringing copies comes in like slightly different combination of blocks, and I think they are required to file 53 cases to protect that box of blocks because the court wants to adjudicate whether each block would constitute work that's protectable or not. So sometimes there are requirements like that British brand owners, it's difficult for them to appreciate, and can find that very difficult to understand. Having said that, the copyright law is coming up for amendment and introduced as a separate heading of protection would be industrial products, industrial design. And under the upcoming copyright law, it is proposed that industrial design be offered 25 years of protection. So, you know, the missing gap of unregistered design rights might be fulfilled by this law. And another thing that I should mention would be if you have a building if you work for an architectural company and you enjoy the design rights over an architectural building, then that's a subject matter protectable under the copyright law. Even arguably, it's just a super big version of a 3D design. Don't ask me why, because copyright law is a result of lobbying by interest group over a very, very long period of time. Okay, next slide, please. So the beauty of copyright protection is that it does not require any registration. The right succeeds upon the creation of it. There is a voluntary registration system in China. So if you have a 3D design that is likely to be protectable, then you can register it with the Copyright Bureau. What it does, it facilitates the proof of ownership. And so if you want to take administrative action at the later stage, then providing that certificate would facilitate enforcement rather than having to explain to the authority on the basis of your rights. And if you look at terms of protection, it's much longer than design patents. So individual is life plus 50 years, and companies would be 50 years after first publication. Okay, next slide, please. So the third type of intellectual property that can subsist in a 3D design would be trademark. The registration is with the China Trademark Office, and the requirement is on distinctiveness, because the point here is not to say, I've come up with a beautiful design, but the point is to protect consumer from confusing that, oh, okay, so this bottle of Coke is not from Coca-Cola, even though it has the same shape, or this triangle shaped is not Toblerone, but actually another brand. The registration process can take around 1 year, but the terms of protection can be perpetual. So some companies would utilize strategies like I'll have the initial monopoly done by the design patent. And then if that design is particularly valuable, then I build up the distinctiveness so that I can register it as a 3D trademark in the future and get perpetual protection over that shape. So next slide, please. So a bit of a guess here. Can people make a guess of which one is registrable and which one is not? So the answer is actually the Zippo lighter that gets through the registration. Other successful example would be the Ferrero Rocher chocolate, as well as the Toblerone 3D, the triangular shape of the chocolate. Then the soy sauce bottle failed for registration because there's a lot of bottles already available in the market of that shapes. The Fanta bottle and the Gibbs guitar failed for similar reasons. So again, it highlights why China is an important market for early protection, because if you do not enforce your rights, then next thing you know, that then the design become quite commonplace, and it will affect downstream how you build up the reputation that you are you represent the design, it should belong to you.
So you're saying, Christine, you're saying that the Zippo lighter, there weren't similar products on the market beforehand, therefore they were in a better position to enforce. Is that the fundamental point?
That's right. That's right. So the soil bottle, I think people said it's very early application as well, but then the court found that by 1993, there's already soy sauce manufacturers that's using bottles of a similar appearances. Mm.
Okay, thanks.
Okay, so I can move to the next slide. The last types of IP rights that can subsist in a 3D design would be trade dress. The requirement here, you can think about trade dress protection as the unregistered 3D trademark, because the point here is also when you see the packaging, when you see the design, it's identified with a well-known product from a particular maker that signifies the source. And the rights is not acquired by registration, but by extensive use and marketing. So similar to 3D design, the trade dress must be distinctive, and it must not be dictated solely by the technical function or by shape of the goods. So next slide, please.
Okay, if I could encourage anybody, if you do have questions, please type them into the box, and we'll happily raise them with Christine. So if there's any issue that you want to raise, please do so. Back to you, Christine.
Yep. So examples of successful enforcement of trade dress. That's the case about the Wang Laoji. It's a herbal tea can. So the protection is the red bottle with the yellow font on it. This is a dispute between the company Wang Laoji versus its distributor, and it's a very significant case in China because the owner decided to terminate the distribution agreement, but then the bottle and a lot of the promotion surrounding it is being built up by that distributors. So it's a case of the right owner trying to get back the goodwill that subsists in that trade dress, and Wang Laoji ultimately won. So you see how the distributor, the game that they are playing now is to put in huge amount of marketing budget into, and people in China would know who watch the popular TV program, The Voice of China, is a singing campaign, and how they are just pouring marketing budget after they have changed the color of the bottle to gold. And Ferrero chocolate, again, is a very popular product in China, especially in the Spring Festival. I think the intern in my office still reminiscent of how if they do a good job, like their parents will give them a chocolate. And so this design is well protected, and they've obtained a lot of successful enforcement with damages in the region of the millions. So some industrial design, like the steel saw with the gray and orange color combinations, are also examples of successful enforcement of trade dress. Okay, next slide, please.
Just, Christine, I have a question here from Angela, which might sit well at this point, which is, can you tell us about character brands and protection that may be offered to protect a brand such as Hello Kitty or smaller brands aspiring to be Hello Kitty?
Hello Kitty, in terms of the design, it's a bit sensitive because Hello Kitty is of course a bird client here. So I can tell you less than what other people can.
Okay, well, don't talk about. I think the person's just raising an example of it's not a product, it's maybe not a physical thing, but there's an image or there's a part of design that goes on to lots of products. I think that's the direction they're going in. So let's pretend we never said Hello Kitty.
Okay, in terms of character, like a design can be 2D as well as 3D. So the character of a you can protect that as a 2D design. So if you print the face of a Hello Kitty onto a bun, like or your dessert, then arguably there is infringement issue. And then of course, if you have a 3D design of a Hello Kitty rice cooker or Hello Kitty hairdryer, that's of a particular design, then it can be protected as well.
Okay, so there are ways of doing it. Okay, thank you. I'll move along.
Yeah. And in terms of IP enforcement against infringers and imitators, right? I think we can go to the next slide. Like Tom has mentioned, there are a number of different ways. You can file a court case with any of the IP courts in China, or you can bring a criminal proceedings if the infringement is on copyright or on trademark, because there's criminal sanction available. or you can go for administrative proceedings, complaining to the local. For design patent, it will be handled by the patent office, whereas for copyright by the Copyright Bureau, and then for trademark by the Administration for Industry and Commerce. So there are different government departments that handles administrative proceedings. What will happen is that you file a complaint, they look at your rights, and if they accept the complaint and the evidence, then they will raid the factories or raid the shop and order them to stop, as well as issuing a fine. But damages is not available. So if you want to get damages, then you have to either negotiate with the infringer or go back to the civil proceeding route. And patent is also registrable with the custom border control in the different ports in China. So if you have a design right, you can educate, record it with the GAC, and then educate the custom officer of it. And so typically they would require some kind of tip-off on which container or which shipment would contain the infringing goods, but they do have very strong power to then detain the goods and put on that particular exporter on watch. What measure would be suitable? It depends on the particular product. It depends on the infringer that you are facing. For example, like a lot of the people complain about civil proceeding is because it takes anything, it can take anything from 6 months to 3 years or more, depending on the particular judge and depending on the particular court. This is because case management is handled very largely by the discretion of individual judge. So that's why sometimes you hear people with very good and satisfactory feedback and successful enforcement, but sometimes you hear a lot of frustration. And I think Tom would get a lot of those people complaining how my case has been pending for years. There's no reason why it should be like that. And meanwhile, it means that once the product cycle lapses, then the design wouldn't be as valuable or worth protecting. Which is why for design patent, we are observing that administrative proceeding is 10 times more popular. So about like 2,000 cases versus 200 cases in that ballpark, administrative cases. And it's also cheaper cost. The downside of it is, yes, it can be fast, but then the local patent office people, they have a discretion on whether or not to act on the complaint. So unless it's a straightforward copying case, if they see that, you know, I can't quite see if it's the overall similarity or not. You say they copy your color, but I say it's just a commonplace blue. I don't see what's the particular design that people are trying to assert. Then they can just refuse to act, and in that case, then again, it's left to the discretion of individual officers, and can be a very subjective exercise. With border control, can be very effective. I think sometimes you see people who fall apart with their OEM, then put the OEM on the list of border control to make sure that they wouldn't be exporting the design, which now becomes infringement. The downside is you have to act very quickly when the officer notify you of a potential case. You have to, I think, go there within 3 days to verify whether the goods are genuine or infringement. You have to put up security bond and promises to take action afterwards. I think we can go to the next slide. So in terms of infringement standards, the standards is very similar to international requirements. For design infringement, it will protect identical design on identical or similar products or similar designs. For copyright, the requirement is similarity plus assets. And then for 3D and trade dress, it has to be the design has to be confusingly similar. So the emphasis here is placed on confusion. Next slide. Right, so turning to what's the best practice here. I think the best practice, as we have emphasized during today's presentation, would be that you have to register your rights, so that if infringement happen, you have something to fall back on and to enforce. With the system and how it works, yes, maybe only 60% of the cases will or complaint will achieve the effect that you want. But if you do not register, then you will find yourself into a situation where, you know, there's a Canton Fair happening tomorrow. There are 10 booths with the displaying a product that infringement my design, and yet I can't do anything. The second aspect is register the right even if you have not entered the China market yet. And the reason is the requirement on design pattern is novelty. So if you do not register right now, then you would miss the deadline to have a valid rights in China. The third aspect, get the contract right. If you do proper due diligence against your OEM, against manufacturers, suppliers, a lot of infringement cases happen because distribution agreements are terminated. Who would be the most likely person that can best copy your product? Your previous supplier. And then the next aspect of it, gathering intelligence on the pattern about infringement and what's happening is important. And different strategy and different legal budget should be tailor-made to that strategies. So if you're looking at a lot of takedown notices on like Alibaba websites, then you don't need to hire very expensive lawyers to do that. A lot of companies can handle that themselves. And there are also programs like by UK IPO, like discussion with Alibaba on can things be improved, such that some kind of filter can be set up or some kind of data can be shared with the right owners. And custom recordation, moving on to the figure of the ship. There are a number of different ways you can utilize to enforce the rights, including custom recordal. And bear with us on the frustration with the system, because we understand that with the particular characteristic of the China system, like the time period that it takes as well as the paperwork, it requires more effort than that in the UK. Like everything in China needs to be notarized and legalized. So in order for any law firm to act, they would need to have notarized and legalized power of attorney, or an authorization letter from the right owners. And the legalization process can take up to, say, 1 month. So if you want to act very quickly, then you should line up somebody and get that legalization or notarization done first. Or you have to plan ahead, plan typically 1 or 2 months ahead to allow actions to be taken. So regarding the cost of the infringement, I think ultimately it's an economic gain. Like sometimes, what's the legal budget that should be allocated? One concept can be, what's worth stealing is worth protecting. So that's the cost of the, and you should work with your lawyer on how to deliver an overall proposal, not just reactive in looking at, oh, here's the problem and I'll find a way to solve it, but proactively think about what is really happening and what's worth spending money and what's not. So with that, I can move on to the next slide.
Thanks, Christine. I have one quick question from Daisy, and I suppose it's one of probably the $64 million question in these sorts of things, but she asks, if you register, are you not giving away details of your product anyway? I suppose it goes to the heart of maybe if you had a sensitive piece of design or something that you didn't want in the public domain at all. Is there any way around that situation?
So if you have a sensitive design that you do not want to disclose, the application filed with the patent office is confidential, and it would not be published until a later date. So I think that can be managed and taking into account the 6 to 8 months period. So before you put the design onto the market, is protectable as a trade secret. So Apple, for example, they got the Apple iPhone design with their life and sue anybody, not for design infringement, they rely on trade secret protection before the product is put on the market. But make sure that you file the application maybe at least a week or 1 day before you launch, so that you can get it both ways.
Okay, interesting. That's an interesting piece of advice. Thanks. Okay, on to the case study.
Right, I'm conscious of time here. We are already an hour, so maybe I'll just very quickly go through some of the examples, and then we can open for more questions if necessary. So I just want to illustrate some recent cases so that the audience can get a perspective of what's happening. So here we have a frustrating example of what's considered as not similar. And here you have the design on the left and the alleged infringing scissors design on the right. The infringer said that the design is different from two perspectives. They admitted that the overall shape is similar, but then they said it's common configurations. And they said the color is different, and also the size of the rivet on the part that connecting the blade are not similar. And the court agreed with them. The court said disagree with them on the color aspect because the design registration does not specify any color, and therefore it will catch any copying with the shape, irrespective of the color that they use. But on the rivet, they said that because it's the center of the design, and therefore that's where people would pay attention to. Of course, you can disagree with that, but that illustrates how sometimes things can get very subjective. Yep, we can move on to the next example. With the Dyson dryer, they have more luck with the design infringement against a Zhejiang company. And they sue they are brave enough to just take action against them in their local courts. I think you talk about local protectionism and all that, and it is happening. But sometimes it's, if that's the only option that you have, I think people should still try. Courts in the south, like in Zhejiang, in Jiangsu as well as in Guangzhou, are getting more and more experience with enforcement. And in that case, they ask for damages of 50,000 pounds, and they get 20% of that, so 10K. So it is an example of how the aspect of the U shape where you put your hands in are protected, despite there are other design differences, like the steps at the bottom of the dryer. So they got an injunction despite these differences. But regarding damages, the average amount of damages in China is still very low. So next slide. And Ferrero Rocher is, like I mentioned, very successful example of trade dress and 3D trademark enforcement. In that case, the court, the protection of the design is over any packaging of chocolate with the golden paper round shape, brown paper underneath, and a small circular sticker in a transparent plastic box. So despite the clear placing of the brand on the infringing design, the court still found that's taking advantage of another highly distinctive trade dress. So next slide. Thoreau has also been actively enforcing the rights using other ways of enforcement. And this time is the administrative action in 2015 and just in this year. And they got a fine of, so the fine is not available to the brand, to the company, but will be collected by the AIC. But the fine is in the region of 2 million, so about 200K, and that's quite substantial. So in China, I think afterwards, companies can then take a civil action, not treating it as a court case, but as a kind of damages collection action. And in China, damages is available on account of the companies, the right owners lost, as well as the illegal profit made by the infringer. So next slide. Yeah, I think that reached the end of our presentation today. David, do we have more questions coming?
I'm pretty conscious of time, actually. So if and I've dropped most of the sort of questions that had a context to our presentation today in as we went along. So I think we might wrap it up reasonably quickly. I'd like to just jump across to Tom. Tom, are you on the line there with us?
Yes, I'm still here, David. Yep.
Are there anything perhaps that you'd like to add from what Christine has introduced?
The one thing I would point out, perhaps in addition or complement the points that Christine raised there, is regarding IP infringement actions in China. We have dealt with a lot of questions from British companies about how effective the IP enforcement system can be, and particularly for smaller companies that are operating on a budget which is perhaps restricting them from undergoing a long-term enforcement campaign against infringers in China. Often we get asked the question, is it really worthwhile for small and medium enterprises to even bother with enforcing their rights in China because their budget is limited and perhaps the system is not able to give them the response that they want? It's not a very easy question to answer. The good news is that any single IP enforcement action in China can be much more affordable than an anti-infringement action in, say, the High Court in London or in the US or in parts of mainland Europe. However, the bad news is that any single enforcement action in China is probably going to be less effective at stopping an infringement than a case in the UK court, because people generally respect the UK court decisions very, very closely and will do what the judge tells them, whereas in China, sometimes the first time that people get told to do something by a judge, they ignore it, and it takes a significant application over time to really make a difference. So this is not great news for companies operating on a small budget. However, our response, we have two main points in response. One is that it's often a good idea to take some action, because that sends out a warning to potential infringers saying that you are not prepared to accept infringement of your IP rights when it undermines your competitiveness as a company in the global market. And that may well scare off some of the more opportunistic infringers to go off and engage in different types of business, perhaps infringing other people's IP rights, but crucially protecting your own. And secondarily, if you find that these infringements really are starting to impact upon your business, you need to be quite cool-headed and to really undergo a cost-benefit analysis, if you like, and work out where is this infringement really damaging my business. So it's annoying and frustrating and emotionally upsetting to see infringement of your rights anywhere in the world. But when it really, really gets important is when you start to see infringing products eating into your own market share in your key markets. So perhaps smaller businesses may only be selling within the UK or within Western Europe or within one or two other global markets where they have a particular relationship or interest. So if you start to see infringing products there, those are the cases that you really need to enforce. And whereas it may be nice to stamp out everything, you need to protect your bottom line and your market share in the first instance. So really prioritize, if you have a limited budget, against those infringements that are undercutting your own sales. I thought I'd just add that quickly because that is quite a common question that we get from businesses in the UK. It's not easy to work through, but myself and my team are very happy to have a conversation, a telephone call or a one-to-one meeting with anybody who wants to discuss more the situation or strategy in their particular situation. But that's it for me, David. Thank you for hosting today, and I'll hand back to you in London.
Yeah, thanks, Tom. And I think the key message here is not one of great doom and gloom, in the sense of, companies really should look at China, and it doesn't matter where your size is. You should at least think about China now. Come and talk to organizations like the China-Britain Business Council, like UKTI, like Tom at the IPO, and other organizations. China is a brilliantly exciting, challenging, developing market, and I can demonstrate multiple small brands and small companies, and even big ones, that have done fantastic things in China. But this IP issue it can be one of those sort of soul-destroying or heartbreaking things to see, or as you said, Tom, to see the emotional impact of seeing your product infringed, and that's starting to eat in on your reputation and on your bottom line ultimately. Before we wrap up, maybe Christine, if there's any final thing that you'd like to say, or final maybe top 3 tips or something like that you'd like to wrap up before we finish.
Sure. Top 3. So first thing is registration. That's a message that we repeatedly emphasize. Secondly is know your opponents. Like Tom has said, you can there's a lot of emotion involvement on that when you see someone copying your innovations. But ultimately, is this going to affect your business? I've seen airline decided not to take action against a particular infringing company. They said, if I struggle in making a profit, probably they will die out very soon. Thirdly, there are a lot of low-cost action as well. So yes, it's not 100% effective, or even maybe 80% there, but don't lose out, because there are a number of cheap action that can be taken very quickly. Like we said, the takedown notice on Alibaba can be done very easily, as well as complaining, the non-legal aspect of complaining, for example, to trade fair organizers to take down an infringing display. And these things should be thrown in the mix when considering a particular strategies.
Great. Well, thank you very much, Christine. Cheers, Tom, as well. I'm just going to wrap up. Thank you to our speakers. Upcoming webinars to be aware of: 19th of August, patent protection in China, and 27th of August, provisions in new revised advertising law. So there are 2 upcoming webinars that might be of interest to you. Check them out on our website and do sign up. Other than that, I have nothing else to add for today, but once again to thank our presenters and speakers, and wish all of you happy China business. If you have any questions or any feedback, please do contact me. I'm David. You'll find my email in all of the collateral that you receive about this webinar. If there's any other topic that you'd like us to cover, or indeed you might think that you yourself have a topic that would be helpful to businesses doing business in and with China, please do recommend it. We do lots and lots of these sessions. Other than that, thanks very much, and I wish you all a great day. Bye-bye.